안녕하십니까. 키타 남가주 한국기업회 10월 정기세미나에 참석해 주셔 감사드립니다. 저는 키타 특별 회원사로 활동하고 있는 스캇 리 변호사라고 합니다. 오늘 노동법 세미나에 관해서 저희 마커스 리 변호사님을 소개해드리고 싶습니다. 마커스 변호사님 시작해 주십시오.
네, 안녕하세요. 저희 이름은 마커스 리고요. 죄송하지만 며칠 동안 감기 때문에 저희 목소리가 좀 변해서 이해해 주세요. 저는 여기 루이스 브리즈보이 비스가든 스미스 법률회사에서 파트너이고요. 샌프란시스코랑 라스베가스 두 로케이션에서 노동법이랑 고용법 담당하고 있는 파트너입니다. 이 지난 2월 달에 기타 위에서 제가 지난번에도 노동법 프레젠테이션을 해드렸는데 다시 초대를 받으면서 다시 제가 새로운 employment law 업데이트를 해드리겠습니다. 이 지난 6개월 동안은 특히 캘리포니아에서 새로운 노동법이 좀 많이 생겨가지고 제가 좀 천천히 하겠지만 좀 커버할 포인트가 좀 많이 있습니다. So I'm going to do this presentation in a mixture of English and Korean, mostly English. As with the last seminar in February, if you have any questions, each slide has both Korean and English on it. So feel free to follow along in whichever language you're most comfortable with. If you have any questions, please feel free to type them in the chat box, either in English or in Korean, and I will do my best to get to those questions as soon as I can. But this is going to be the labor and employment update for California for covering roughly the last 6 or 7 months. There have been quite a few new legal developments in the state of California. So as a reminder, if you can just keep your microphones muted for the presentation, that would be great. Thank you. So we're going to be covering both non-COVID and COVID-related updates. We'll start with the non-COVID related legal updates first. So pay data reporting. So 한 2년 전부터 캘리포니아 주가 어떤 새로운 reporting obligation을 만들었습니다. So California required that employers who have over 100 employees are required to provide demographic data to the state of California. This data was supposed to, when you do the reporting, you're supposed to provide the number of employees that you have by race, ethnicity, and gender. There were also civil penalties that were going to be imposed on employers who failed to submit this reporting data. Over the last couple of years, there's been a lot of confusion from employers on what exactly and how they're supposed to report, especially if they don't know the race or ethnicity. And I have not personally seen any penalties be imposed, but we have not seen a lot of clarifying information on how the reporting is supposed to be done. What we have seen is we've seen that law expanded. So 이번에부터 starting from the end of this year, this change goes into effect, if I'm remembering correctly, January 1st, 2023. So that means, because the reporting usually is in April. 보통 그 매년마다 리포팅 해야 되는 그 데드라인이 4월 초쯤이에요. 그 지난해를 해서 일했던 직원들에 대해서 demographic statistics를 그 다음 4월쯤에 리포팅을 해야 됩니다. So starting from 2023 around April, now the requirement will also be expanded for California employers who have 100 or more employees to also report pay scale data as well. And so this is causing a lot of trouble for large employers who are trying to understand what this means. In simplest terms, what it means is that for every job position that you have as an employer in California, you are now required to report the minimum maximum salary or wage for each position. And you also have to report for that position how many employees you have that are Caucasian, Hispanic, Korean. You also have to report whether or not those employees in that position are male or female or other. And all of this information is supposed to be reported to the state of California every single year, starting from this pay scale as well, starting from next April. So the link to where you can report that information can be all done online. That link is right there on this slide. There are a lot of employers with a lot of questions about this reporting. If you have any such questions, please let me know. I'm not going to go through all of the information on this because we're limited on time today. But this is something that every employer who has more than 100 employees is supposed to do. The second update to non-COVID California employment law is an expansion of the term family member under the CFRA. So the CFRA law has existed for some time. 이게 원래 있었던 법이고요. What this particular law did is for employees who have worked for a company for over a year, over 12 months, or over a certain number of hours, which is around equivalent to 1 year of working. For those employees who have worked that amount of time, employers are required to provide those employees with at least 12 weeks of job protected unpaid leave to take care of someone else, a family member or themselves, or to bond with a new child. That basically means you don't have to pay them, but you also cannot fire them. And when they want to return, they have to be able to return to that same job. That's the CFRA, which is a California specific law. There is a federal law equivalent called the FMLA. It's effectively the same, except California, the CFRA is a little bit stronger with certain details. But in any case, the update that happened this year is that starting from this year, family member definition has been expanded to also include, effectively to include domestic partners. So it's including individuals whose association with the employee is the equivalent of a family relationship, effectively same as a family member. So that would effectively include domestic partners. So just keep in mind that CFRA is a law that requires that you have to provide leave to someone who needs to take care of themselves or a family member for a serious health condition. One quick note before I move on. California, in my opinion, practicing employment law in California now for more than 10 years, I think that disability leave, disability accommodations, and potentially being forced into a situation where you have to terminate an employee who is performing poorly, but has also had certain medical conditions. To me, that is the most difficult aspect of employment law for employers in California. Part of the reason it's so difficult is because of the number of laws that are required to be taken into account in these situations. I've listed the laws here. Maybe you've heard of the ADA, the Americans with Disabilities Act. Most of you have probably not heard of the California Family Rights Act until this slide. There's also PFL, which is paid family leave. There's PDL, which is pregnancy disability leave. There's the FMLA, which is the Family Medical Leave Act. There's also general disability discrimination prohibition, which is, I forgot to list it there, under the Fair Employment and Housing Act, which is FEHA. There are quite literally 6 different statutes. These are not one sentence statutes. These are large bodies of law that apply to disability. So if you have a complicated situation where someone is in need of a leave of absence, but there's performance issues, there's perhaps pregnancy related, multiple laws can mix together to make the situation quite complex. So please do not hesitate to reach out to an attorney to ask for assistance on how to handle this. Disability leave in California is one of the most complicated topics in employment. Compared to that last slide, this is a very simple one. 이건 아주 간단하게 bereavement leave가 이제는 캘리포니아에서 생겼습니다. So starting from this year, there's now required bereavement leave in California. Very simple, hopefully not too difficult for most employers. So employers with 5 or more employees must now provide up to 5 days of unpaid bereavement leave for an employee within 3 months of the death of a family member. So still a little unclear what family member means here. Does it mean the same as family member is defined under the CFRA? Just to be safe, you should be over-inclusive of family member. So if an employee has a family member, a spouse, a child, a domestic partner, if someone passes away, then within 3 months of that passing, employers are now required to provide up to 5 days of unpaid leave. Again, that means you cannot terminate them. Because of that, you have to protect their job and allow them to return to work. It seems a little bit short. I mean, who can get over the death of a loved one in 5 days? That's going to be impossible. But it is the first of its kind in terms of requiring employers to provide at least 5 days. So that's just the new development in California. Motor vehicle tracking. So employers have always been allowed to place tracking devices on their company vehicles. And companies do this for a variety of obvious reasons. You want to know how fast your vehicles are going. Is anyone speeding in the company vehicle? Where is the company vehicle? Is it being used for side errands, or is the driver going directly from work site A to work site B? This has been around for forever. There is now a new limitation in California that if a company does use that sort of tracking technology, the tracking technology must only be used during the work hours and only for tracking vehicles that are being used for work duties, for work projects. So for example, you cannot track a vehicle that a company was allowed to take home. They just took it home and they parked it outside their house. You cannot track that vehicle after the employee has left work. Or even during the work day, let's say that the employee, because it's the only vehicle they have, maybe they're using that vehicle to go do a quick run to the local restaurant to get lunch. You cannot use that tracking device to track where they're going to lunch. So the way to do it is ideally companies who are using tracking devices for their company vehicles, ideally you would just have a shutoff or programmed shutoff to turn it off during off hours. If that's not practicable, that would be the best way. If that's not practicable, then the second alternative would be to provide the drivers with the ability to turn off the device during non-work hours. So the law requires that the company provide information to the driver about their right to disable the device during non-work hours. Pretty simple, pretty straightforward. Let us know if you need any help in drafting that kind of notice or information. It's a pretty simple project, but just something to keep in mind if you have any company vehicles. Abortion laws. Okay, so I'm sure everyone here has heard of the Supreme Court of the United States overturning Roe versus Wade. Obviously, this is not a political discussion. This is just a neutral observation on what's been happening subsequent to that decision. So as a technical matter, just so that everyone is on the same page, what Roe v. Wade did was it made it legal again for states to make abortion illegal. What I mean by that is it didn't make abortion illegal across the country. I'm sure most of you are aware that what the decision did was states can ban abortion, and other states can also choose not to ban abortion. It's just up to each state to decide what they want to do. So after Roe v. Wade was overturned, some states decided to ban abortion. Other states, such as California, went the reverse way and attempted to protect abortion and individuals' access to abortion even more. What's currently happening is that when there are individuals who want to get an abortion, who are living in a state that made abortion illegal, some of those individuals are now choosing to travel to states like California to get an abortion because it's legal here, and then simply returning to their home state after the abortion is over. And what's happening in their home states is some of those home states are encouraging investigations and prosecution of those individuals who are fleeing their states to get the abortion done and returning. What California is doing is there are 3 new laws that are designed to protect the privacy of individuals who are seeking abortion, regardless of whether they are California citizens or not. So that applies to companies because sometimes companies are now being subpoenaed. They're now being issued legal requests to produce information, if they have it, about abortions. So let's go through these 3 new laws, just so you're aware of what's happening in California now. So the first law is AB 2091. Employers are no longer allowed to release information identifying or relating to a person seeking an abortion. So if your company happens to get information about someone seeking an abortion, you are no longer allowed to release that information. That even includes, the language of the law gets tricky, and there's going to be some very heavy litigation in the future, because the law is unclear as to what happens. Let's say the state of Alabama, they send a subpoena to a California company to produce information on somebody who supposedly got an abortion. Traditionally, each state is required to honor the subpoenas of every other state. That's the only way the legal system works. Every state is supposed to respect every other state's subpoenas and legal judgments. These 3 new laws are pushing that boundary by trying to make a new line saying, we will not honor other states' subpoenas if it has to do with abortion. So if you look at the second one, AB 1242 now prohibits electronic communications or computer companies from complying with out-of-state warrants or subpoenas for an investigation relating to a lawful California abortion. Let's say Alabama Company A has an employee who fled to California to get an abortion and then returned to Alabama. Alabama Company A seeks a subpoena from the state of Alabama, from a court in Alabama, saying, we want to issue a subpoena to get information about that abortion. If this person did something illegal, we want to know about that. The court in Alabama agrees and issues a subpoena to California. California and a company in California who has knowledge of that abortion receives that subpoena. The new law basically says you're supposed to ignore that subpoena. That's legally very complicated and unstable. I'll just leave it at that. So for now, for your purposes, when you receive any sort of subpoena or information request of any kind pertaining to an abortion, for now, don't respond to it. Contact an attorney to make sure you are following the most up-to-date status of this law, because I strongly anticipate this is going to change or be removed or evolves in some way in the next 12 months, probably. So contact an attorney for the latest status on this if you do run into this. The third law, very quickly, AB 2223. Generally, it just protects individuals who are attempting to get an abortion. It says that those individuals cannot be pursued for civil or criminal liability or penalties. But that's it. California has been very active on the abortion front. I think this is the last update that's non-COVID related. Marijuana or cannabis use off-site. So 이것은 아직은 effective하진 않지만 1월 1일 2024년 1월 1일부터 it's going to become illegal for employers to take an adverse action against an employee if they used marijuana off the job and away from the workplace, or if a pre-employment drug test comes up positive. So let's back up and talk about what the state of the law was before this. So 몇 년 전부터는 marijuana가 legalization 됐잖아요. So what that actually meant is the use of marijuana in the state of California became legal. That doesn't mean that companies are required to allow people to smoke marijuana in the workplace. What it means is simply that the police cannot arrest someone for simply smoking marijuana. What it still allows for, and still is currently the state of the law, is companies can still terminate an individual's employment if they choose to, because that person is smoking marijuana. Before this AB 2188, which is not effective yet, so this is still the current state. If you drug test an employee right now and they were using marijuana at some point before the job began, in the morning before work began, during their lunch break, whenever, or on the weekend, any company can terminate that employee. Even today, you can still terminate an employee for marijuana use. This new law, AB 2188, however, will make it illegal to do that if the employee was using marijuana before they started that job or outside of work hours. So as for whatever reason, on the weekend they smoked marijuana, you cannot terminate them for that off-site, away from the workplace usage. This is not effective. This law is not effective until January 1st, 2024. So there might be some revisions up until then. The issue I foresee with the implementation of this law is that when you drug test someone, it doesn't say what time they took the drug. It just says whether it's positive or negative. So how do you know if someone tests positive for marijuana? How do you know that the marijuana use was during work hours? If you don't know, then technically does that mean you can't do anything against that? So there is a ambiguity in how to follow this law, but still try to maintain a drug-free workplace. So we'll see if there's clarification for this law before it becomes effective in 2024. But for now, just be aware that this is coming down the road. All right, so next we're moving to COVID-related updates. There's not a lot of major changes to COVID-related updates. This is going to be fairly fast, and I'll allow you to just read the slides, which we can circulate to everyone after the presentation. But the first change is in February, during the last presentation that I gave to KITA, we talked about the supplemental paid sick leave in California. And in short, if you already saw that presentation in February, and if somehow you miraculously stayed awake during our presentation and absorbed every piece of information, the short version of this is it was extended to December 31st with no additional changes. But I will take just a couple minutes to review this supplemental paid sick leave because it's so confusing and so complicated unnecessarily. But let me just explain it very briefly to everyone. So first off, it was extended to December 31st. That's the one change that actually took place since February. Let me talk about the actual supplemental paid sick leave again in summary. So what the sick leave does, as a reminder, is it doesn't apply to any employers with 25 employees or less. 그래서 26명부터 이상부터 이게 you have to follow this from 26 employees and more. If you are a company that has 26 or more employees, then anyone that needs to take leave because they are sick due to something related to COVID, they might have to receive up to 80 hours of paid sick leave in California for specific reasons. Now, to be an employee who can receive this, you have to be a covered employee. That means that you are unable to work or remote work for a qualifying reason. If you are able to work or you're able to work remotely, you don't get paid sick leave, but completely unable to work, even remotely, for a qualifying reason. These are the qualifying reasons on the next slide. Again, this is all information that we covered in February, so I'm going a little bit quickly, but you can also review these. No one's going to memorize this now, but you can review these when you receive the slides. Qualifying reason is going to be the state of California ordered them to quarantine. A doctor advised that the employee must quarantine, or there's a vaccination appointment or vaccine booster symptom, or they're caring for a family member who quarantined. So any of these are the qualifying reasons. Caring for a child whose school or place of care is closed due to COVID. So out of those 80 hours, 원래는 그 supplemental paid sick leave에서 80시간을 paid leave로 줘야 된다고 그랬잖아요. 그 80시간을 두 가지 캐테고리로 생각하시면 돼요. 그래서 첫 번째 캐테고리는 40시간이고 두 번째 캐테고리는 40시간. So in the first category, there's a first bucket, first box of 40 hours. Those are going to be for individuals. This is going to be how much time? I thought it was a little bit clearer in the slides, but it's not. Okay, so there's two buckets for the 80 hours. The way the two buckets work is there's one bucket of 40 and a second bucket of 40. So if you look at these reasons on this slide, the qualifying reasons, if anyone has these reasons, then they get up to 40 hours in the first bucket of paid sick leave. So if someone needs to go get a vaccination appointment, they're supposed to be paid for that time to get a vaccination, and that counts up to a maximum of 40 hours. They have a max of 40 hours for that. That's also 40 hours for if they have symptoms of COVID, if they are getting symptoms or ill effect because of a vaccine or booster. And remember, these symptoms are causing this employee to be unable to work, not just a little bit sick. They cannot work, not even remotely. So it's not just, oh, I feel a little bit headache and I don't want to go into work because I got a booster. No, they have to be unable to work. So if they're unable to work because of quarantine or vaccination or vaccine or booster symptom or caring for someone who's in quarantine, they get up to 40 hours. The second bucket of 40 is if they get a document and show it to the employer showing that they actually got diagnosed with COVID-19. So 만약에 COVID-19을 걸렸고 그리고 의사한테 어떤 documentation note을 받았다. COVID-19 확실히 걸렸다. 그러면은 그 두 번째 40시간 버킷이 시작이 돼요. 그때부터. So including these first qualifying reasons plus up to 40 hours of paid sick leave once they actually caught COVID, employees get a total of up to 80 hours of paid sick leave in California. Now that is, as I mentioned, that law was actually started, I forget when it was implemented. It was implemented, so original California COVID sick leave was like 2021. And then in the beginning of this year, it was changed to also include symptoms of vaccine booster, and the buckets were changed a little bit. Anyway, all of this was just pushed out to December 31st. So if you've already been providing leave, the 80 hours doesn't start again. 다시 시작하진 않아도 되고요. 그냥 원래 썼던 시간을 계속 줘야 돼요. 남아있는 시간을 계속 줘야 돼요. And these are the 40 hours for qualifying reasons. We already talked about this. It's a little bit of complicated math, but you can review that on your own. If there's employees who are less than full time, you don't have to give them the full 40 hours. And then this is the second bucket of 40 hours if the employee tests positive for COVID. And there were some slides. These 3 or 4 slides on California paid sick leave are almost exactly the same from the February presentation. So I'm kind of going over them quickly because it was just complicated back then. So I wanted to just summarize briefly. It's the same law. It's just been extended to December 31st. Okay, mask mandates. California now only strongly recommends, but does not require masks in public indoor settings. There are still certain areas where masks are still required. For example, senior care facilities and prisons, shelters. But now overall, other than these specific areas, masks are no longer required. Vaccine mandates. So some of this is kind of old news. There's no federal law allowing for vaccine mandates. And California was causing some news again. Earlier in the year, the state was considering making vaccines mandatory for all public school students at grades 7 through 12. They were effectively going to make all students in California at public schools required to receive a vaccine from 7th through 12th grade. That particular law that they were discussing about 4 or 5 months ago, they've pushed that law out to at least July 2023. Probably by then, I don't expect they're actually going to pass that law. I don't think that law is going to pass, mostly because the statistics right now seem to indicate that 80%, 80% of California residents are fully vaccinated. So with there being such a high amount of vaccinations in the state, requiring additional vaccination requirements is now being considered less necessary than before. And for politicians, also being considered politically potentially risky, given the potential health benefit of it. So there's a little bit of a less desire by the California legislature to pass very harsh COVID-related laws, given the less than previously serious health considerations of COVID-19. So I don't think this law is going to actually come into effect in July 2023, but something to keep an eye on. Teachers are still required to be vaccinated at public schools. That's still required, although I think there's been a legal change, which I didn't include here because I assume no one here is involved with a public school, running a public school, but there's less reporting requirements for teachers. They need to be vaccinated, but I think the requirements connected with that are a little looser now. I'm not aware of any cities that actually still have a vaccine mandate. There were many cities, even as of last February when I gave this presentation to KITA 7 months ago, Los Angeles, San Francisco, many other cities required proof of vaccination if you wanted to go into a restaurant or a bar or some other such kind of public, public area, public space where people are in close proximity. All of those cities have since lifted those mandates. So the only city I'm aware of that has anything related to that still is Oakland, that they still have a vaccine mandate for anyone entering a senior center. For some reason, I would have expected San Francisco and Los Angeles to also have something similar to that, but I couldn't find anything like that. So as far as I'm aware, Oakland is the only one that still has that. And that's it. It's a little bit short this time because this is really just employment law updates for the last 7 months. But if you have any questions, you can feel free to leave them in the chat. Also, Jessica Lee has left email addresses for both Scott Lee and myself if you have any questions. Again, you can leave questions on employment law in the chat, or if you would like, always feel free to email both myself and Scott Lee with any employment law related questions. Also, please bear in mind that we have our law firm has 1,600 attorneys that practice all areas of law except for criminal law and family law. So if you have any legal related questions, pretty much of any kind, please feel free to reach out to Scott Lee or myself. Thank you to everyone who attended. You're free to take off if you'd like. I'm going to answer some questions in chat that I see right now. So I believe in terms of the recording of the presentation, I think that KITA is going to have that available. I will see that they address circulating that or making a link available. I think it might be on YouTube at some point. I see a question: can an employer mandate vaccination for its employees? Yes, you can. Excuse me. vaccinations can be mandated by companies. However, you would also, just like the government, when they tried to do it, you would be required to provide exemptions for medical reasons and for sincerely held religious belief. So if you allow those two exceptions, you can provide mandates. Gets a little tricky in terms of the religiously held belief and what does that actually mean and what qualifies, but we can cross that bridge when we get there if you have a question on that. But general answer to your question, yes, employers can mandate vaccines. Oh, I guess that's it for questions. I'll stick around for a few minutes in case there's other questions, but I guess other than that, Scott.
예, 예. 많은 분들이 참석해 주셔서 감사드리고요. 다음에도 또 저희 세미나를 할 텐데 혹시나 노동법이나 다른 법에 대해서 궁금한 점 있으시면요. 국장님을 통해서 인포메이션 보내주시면 저희가 웨비나를 또 준비하겠습니다. 예, 감사합니다.